The United States. How many of us really consider what it actually is? Is it one nation, indivisible, as so many of us state during the Pledge of Allegiance? Is the federal government supreme in all of its laws? Where do the states fit in? Why does every state have a government of its own if our federal government is supreme? There's always been a lot of controversy over the relationship between the federal government and the states, but this conflict can pretty much be boiled down to just one word: sovereignty. Sovereignty can be defined as the supreme power or authority, or as the authority of a state to govern itself or another state. And this is the crux of the battle between the states and the federal government. Who gets to tell who what to do? Well, generally when there is a dispute with anything, you go back and look at the original agreement, in this case, the Constitution. But the 13 colonies preceded the Constitution. So were they sovereign before the Constitution was written? For a proper understanding of not only the relationship between the states and the federal government, we must look to the explanations of the founders, what many refer to as the original intention. This is what was decided upon during not only the Constitutional Convention, but the state ratifying conventions as well, for it was the states individually that ratified the Constitution. James Madison wrote, "If the sense in which the Constitution was accepted and ratified by the nation be not the guide in expounding the Constitution, there can be no security for a faithful exercise of its powers." On the heels of the convention, Justice James Wilson, who had been a leading framer and ratifier, said, "The first and governing maxim in the interpretation of a statute is to discover the meaning of those who made it." Justice Joseph Story reiterated that the first and fundamental rule in the interpretation of all instruments is to construe them according to the sense of the terms and the intention of the party. Very early, the court declared that construction must necessarily depend on the words of the Constitution, the meaning, and the intention of the convention which framed and proposed it for the adoption and ratification to the conventions in the several states to which this court has always resorted in construing the Constitution. Many activists argue that over the years words change their meaning, but that doesn't authorize us to settle the founders with our meaning. To change the meaning that the words had for the founders is to change the Constitution itself. Chief Justice Taney declared, "If we are at liberty to give old words new meaning, there is no power which may not by this mode of construction be conferred on the general government and denied to the states." And this sentiment was shared even after the Civil War by the Reconstruction framers. In January 1872, a unanimous Senate Judiciary Committee report signed by senators who had voted for the 14th Amendment stated, "A construction which would give the phrase a meaning differing from the sense in which it was understood and employed by the people when they adopted the Constitution would be as unconstitutional as a departure from the plain and express language of the Constitution." In summary, it is established learning that what the Constitution meant when it left the hands of the founders, it means today. In most cases, activists' attack on the original intention of the Constitution are generally because they did not get the changes that they sought from the court. Now, in sorting through the facts of the conventions, it should be kept in mind that as the debate progressed from the floor of the convention to the arguments the Federalists addressed to the ratifiers, and then to the state ratification conventions, a given speaker may have changed his mind. The person most often cited for the view that when the colonies separated from Great Britain, they were a unified nation is James Wilson. In the Constitutional Convention, he refused to acknowledge that when the colonies became independent of Great Britain, they also became independent of each other. He read the Declaration of Independence as stating that the United Colonies were declared to be free and independent states, but inferred that they were independent not individually, but unitedly. Alexander Hamilton also shared this view. Even Justice Story, who also believed that the United States was fundamentally one nation, wrote that although the colonies owed a common allegiance, they had no direct political connection with each other. Each was independent of all the others. Each was sovereign within its territory. There was neither alliance nor confederacy between them. A historical note to remember is that earlier in 1754 at the Albany Convention, 8 of the 13 colonies had made an attempt to agree on a plan of union for common defense against the French and Indians. Samuel Eliot Morison recounts Not one colonial assembly ratified the plan. Every one refused to give up any part of the exclusive taxing power, even to a representative body. In fact, the relations of the colonies with one another were often unfriendly, usually as a result of rival land claims. Actual warfare had only been prevented by the external power of Britain. The colonies themselves were separated by different origins, traditions, and above all by distance. So before considering James Wilson's deduction from the Declaration of Independence, it is important to examine the immediately preceding resolution proffered by Richard Henry Lee and the Continental Congress, which was voted on July 2nd, 1776, that these united colonies are free and independent states, that a plan of confederation be prepared and transmitted to the respective colonies for their consideration and approbation. Notice that the united colonies were not declared to be a United States, but instead independent states, a result dictated by the instructions that the delegates had received from their states. During the debate, it was stressed by leading figures that the colonies were as yet perfectly independent of each other. That such independence was recognized is evidenced by Lee's recommendation that a plan of confederation be submitted for approval by the respective colonies, a recommendation that flowered into the Articles of Confederation. 2 days later, on July 4th, Lee's resolution was followed by the Declaration of Independence. Jefferson's original title for the Declaration was "A Declaration by the Representatives of the United States of America in General Congress Assembled." On July 19th, an act of Congress changed it to "The Unanimous Declaration of the 13 United States of America." The change from "Representatives of the United States" to "the 13 United States" demonstrated the unreadiness to forge a nation and a will to preserve the sovereignty of the states, as is confirmed by the fact that the signatories subscribed separately on behalf of each of the individual states. Justice Samuel Chase, who had been a member of the Continental Congress, declared in Ware v. Hilton, "I consider this a declaration, not that the United Colonies jointly, in a collective capacity, were independent states, but that each of them was a sovereign and independent state. That is, that each of them had a right to govern itself by its own authority and its own laws, without any control from any other power upon earth." Justice Story, who favored the nationalist view of the Union, contended that the Declaration of Independence was the act of the whole people of the United Colonies, and not individual states. He further stated that separate independence and individual sovereignty of the several states were never thought of by the enlightened band of patriots who framed this declaration. Yet the people didn't act as a whole. They acted severally through their representatives that were sent to speak on their individual colonies' behalf, just as they later ratified the Constitution as individual states. In fact, they jealously guarded their state independence and sovereignty throughout the framing of the Articles of Confederation, the Constitutional Convention, and the various ratification conventions. When the Continental Congress agreed on November 15, 1777, to recommend the Articles of Confederation to the states, it made the independent sovereignty of the states emphatically plain, reciting that the members acted as delegates of the states affixed to our names. They provided in Article 2 that each state retains its sovereignty, freedom, and independence, and every power, which is not by this confederation expressly delegated to the United States, in Congress assembled. Article 3 provided that the said states hereby severally enter into a firm league of friendship with each other for their common defense. The drafters recited that they acted in the name and in behalf of our respective constituents, not as the collective people of the whole United States. They even signed the document on the part and behalf of the states of New Hampshire, Massachusetts Bay, Rhode Island and Providence Plantations, Connecticut, New York, New Jersey, Pennsylvania, Delaware, Maryland, Virginia, North Carolina, South Carolina, and Georgia. This responded to an instruction by the Congress in November 1777 to its committee to draft a circular letter requesting the states respectively to authorize their delegates to subscribe in the behalf of the state. The continued leading role of the states is exemplified by Article 9's provision that for the management of the general affairs of the United States during a recess of Congress, it should appoint a committee to be denominated a Committee of the States and to consist of one delegate from each state. Article 5 provided that each state shall maintain its own delegates in a meeting of the states, marking them as state delegates rather than as members of the National Congress. This reference to a meeting of the states reflects what was understood to be the meaning of the word Congress. It was understood that it was a formal meeting of envoys, deputies, and ambassadors representing their sovereign states. This is how John Adams, the organizer of the Continental Congress, understood it when he wrote in 1787 that the Confederation was only a diplomatic assembly. In fact, the word government never appears in the Articles of Confederation, and that's because it was a league, not a government. This independent sovereignty was not only plain to see in the Articles of Confederation, but was also acknowledged in the Treaty of Peace with Great Britain on September 3, 1783. Article 1 states that Britain acknowledges the said United States, New Hampshire, Massachusetts, and so forth down the roster, to be sovereign and independent states. Article 5 of the treaty states that British subjects were free to go to any of the 13 United States, signifying that Britain was treating with 13 sovereign states, not with one unitary nation. This sentiment continued to the Constitutional Convention. On June 30th, Gunning Bedford stated that all the states at present are equally sovereign and independent has been asserted from every quarter of this House. Early on, Charles Pinckney laid before the House the draught of a federal government to be agreed upon between the free and independent states of America. William Patterson said, "We are met as deputies of 13 independent sovereign states for federal purposes." Oliver Ellsworth observed that in the hour of common danger, we associated as free and independent states. Jonathan Dayton said, "We as distinct societies entered into the compact." Luther Martin declared, "At the separation from the British Empire, the people of America preferred the establishment of themselves into 13 separate sovereignties instead of incorporating themselves into one." Roger Sherman urged election of senators by state legislature in order to preserve the state sovereignty. The sense of the convention is evident from Washington's letter transmitting the Constitution to Congress, drafted by the Committee on Style pursuant to the convention's instructions. It is obviously impractical in the federal government of these states to secure all rights of independent sovereignty to each. Individuals entering into a society must give up a share of liberty to preserve the rest. For the ability to surrender a share of independent sovereignty shows the pre-existence of sovereignty. Remarks to the contrary are scarce, but there were a few. Rufus King asserted that the states were not sovereigns in the sense contended by some. They did not possess the peculiar features of sovereignty. They could not make war nor peace. But he himself noticed that if the states therefore retained some portion of their sovereignty, they had certainly divested themselves of essential portions of it. It is true that the states had delegated several powers requiring united action to the Continental Congress, but they'd taken the precautions of expressly reserving undelegated powers to themselves. Elbridge Gerry, too, urged that we never were independent states, were not such now, and never could be even on the principles of the Confederation. At the same time, he noted, however, that the states and the advocates for them were intoxicated with the idea of their sovereignty, and he thought the community not yet ripe for stripping the states of their powers. Commenting on the proposed congressional negative on state legislation, he said, "Such a power as this may enslave the states. Such an idea will never be acceded to." These remarks recognize the existence of sovereign states. Pre-existing state sovereignty was confirmed by Hamilton in Federalist No. 15. The concurrence of 13 distinct sovereign wills is requisite under the Confederation. In Federalist Paper No. 39, Madison assured the ratifiers that each state, in ratifying the Constitution, is considered to be a sovereign body, independent of all others. In Federalist No. 40, Madison asked if the states would be regarded as distinct and independent sovereigns, and he answered, "They are so regarded by the Constitution proposed." Ratifiers in the state convention likewise recognized pre-existing state sovereignty. In Pennsylvania, Wilson, departing from his earlier remarks, referred to a country composed of 13 distinct and independent states, it being the task of the Federal Convention to frame a government for 13 independent and sovereign states. His colleague, Chief Justice Thomas McKean, stated that this system proposes a union of 13 sovereign and independent states. In Massachusetts, Bowdoin referred to the several states as distinct sovereignties, and Cabot assured the delegates that the sovereignty of the individual states was represented in the Senate. In Connecticut, Oliver Ellsworth stated, "This Constitution does not attempt to coerce sovereign bodies, states, in their political capacities." In New York, Livingston said, "We have 13 distinct governments." One of the foremost Federalists, James Erdell, referred in North Carolina to 13 governments confederated upon a Republican principle. Chief Justice Marshall, who had been a member of the Virginia Ratification Convention, stated in Gibbons v. Ogden that prior to the adoption of this Constitution, the states were sovereign, were completely independent, and were connected with each other only by a league. Viewed against this background, it is obvious that the Federalists had undoubtedly underestimated the attachment of citizens to their states, and when that fact dawned on them, they bowed before the wind. It should be noted, however, that for the founders, the people were the sovereigns. Power flowed from them, not from the crown, to fill a vacuum. So James Erdell said in North Carolina, "It is necessary to particularize the powers intended to be given in the Constitution as having no existence before." Madison stated in the Constitutional Convention that the people were in fact the fountain of all power. 7 state constitutions expressly declared that all power originates or derives from the people. Georgia, 1777, Fourth Whereas Clause. Maryland, 1776, Declaration of Rights, Article 1. Massachusetts, 1780, Declaration of Rights, Article 4. New Hampshire, 1784, Article 8. North Carolina, 1776, Declaration of Rights, Article 1. Pennsylvania, 1776, Declaration of Rights, Article 4. Virginia, 1777, Bill of Rights, Section 2, 2. Wilson told the Pennsylvania ratifiers that the supreme power resides in the people as the fountain of government. They can distribute one portion to state governments, another portion to the government of the United States. In sum, the colonies, having severed their common allegiance to Great Britain, were sovereign and independent of each other. Lee's resolution of July 2, 1776 attests such independence and is confirmed by the Declaration of Independence signed on behalf of the 13 separate states. That independence was explicitly safeguarded in the Articles of Confederation, which merely set up a league, and it was further recognized in the peace treaty with Britain, signed on behalf of the 13 individual states. So what was the impact of the Constitution on such state sovereignty? Did it consolidate the states into one sovereign? Or did it erect a system which came to be known as dual federalism?